So I think having laid the basic, foundation and premise of this course, which is to understand public administration through the lens of Constitution of India, and to give you the basic structure and the background of the same. I think right now, before we get into our second week and second chapter of trying to get into the details of the Constitution, including the study of the preamble, the fundamental rights, directive principles, state policy, and the aspects of constitutional functions. I think one kind of an issue that we can interlink and bring about a debate is uh, can we define what public policy is under the Constitution? Uh, it's quite interesting that there has been some kind of an attempt to define public policy in India. And you will notice that while we look at the Constitution to define it, it's not written explicitly, but I think it can be read into by the court. And the same was done by the Supreme Court uh, in this Delhi Transport Corporation versus the Delhi Transport Corporation Mazdoor Congress. It's a case of 1991. Actually, this case is very popular on what we call as the rule of proportionality, because please note, one of the issues on public policy is you shall be punished, or there should be some kind of a sanction on you to the extent of the fault that you have committed, not anything beyond that. That is called the rule of proportionality. So I should be punished only to the extent of my fault and default, whatever it is. So I think that is something that this case actually laid down, because a disproportionate punishment is definitely not just, and a just punishment is definitely in favor of public policy. So unjust and just is something that is the element of public policy. Being fair is public policy, isn't it? So uh, um, finally, I think if you see this judgment, it does lay down a very interesting guide, and the guide is like this. The court in 1991, in this case, said the rules which stem from public policy must, of necessity, be laid to further the progress of society, in particular when social change is to bring about an egalitarian social order through the rule of law. Courts can always be guided by that light, and the guidance thus shades the dignity of our constitution. So I think the courts can definitely be guided by various principles, because I think in terms of how to determine what public policy is, you will notice that it can be determined from one generation to another. So there is no perfect test of what it may, and it is not something that is going to be static all across. But someone did say that public policy could be as simple as that which is not opposed to public policy is something that is in favor of public policy. And to a larger extent, people have said that public policy is like an unruly horse. You try to actually control it and define it, it is not going to be able to be done at all, because that is precisely how it looks like. This was actually the public policy was an unruly horse, is actually one of a statement that was given uh, quite some time back. Um, and you will notice that while we apply public policy in so many facets, be it arbitration, be it dispute resolution, be it in cases of taxes and frauds, in all those cases, what is public policy? You'll not probably be able to say in clear terms what it means. To be honest, a lot of people have said, and jurists believe, that public policy is nothing but public interest, a larger public interest, right? Some have also gone ahead and said that it is kind of a political, experience of what is public good. That is what public policy actually means. So I think defining it may not be possible, but I think you can definitely find out and say that something that is contrary to the fundamental law of the land, right, is definitely not public policy. Something that is contrary to the interest of the country is not public policy. Something that is contrary to justice and morality can also be not be in favor of public policy. So I think these are very broad aspects of what you can actually say, but I don't think you can say that in precise terms. However, In terms of the constitution and in terms of public policy perception, I think it's very important for us to take an issue which will probably describe the the importance of this course to the students who would want to probably go deeper in understanding this course. Now, if you look at the Indian Constitution, we have an article in the Indian Constitution, Article 48. This is under the Directive Principles of State Policy, and you will notice that this states the organization of agriculture and animal husbandry. Okay, and what does this say is under the Directive Principles of State Policy, it says that the states or the states which include all forms of government shall endeavor to organize agriculture and animal husbandry on modern and scientific lines, and shall, in particular, take steps for the preserving, improving the breeds, and prohibiting the slaughter of cows and calves and other milch and draught cattle. Now, the reason why I took this up is because, please note, friends, this provision in the Constitution clearly says the states shall take steps to preserve, improve the breeds, and prohibit the slaughter of cows. So this is something that is mandated by the Constitution. And probably you will notice that if I read Article 48, read along with 48A, which was added to the Constitution later on, which says that there must be protection and improvement of the environment, safeguard of forest and wildlife, and the state shall endeavor to protect and improve the environment, which clearly says that cows, it's not only wildlife, but I think anything in the environment is something that has to be preserved. And I think there is an obligation on the state to actually prohibit the slaughtering of certain kinds of animals that are cows in that sense. Now, this has been an interesting question all throughout because very recently cow slaughtering legislations have come under some kind of a media scrutiny. People have suddenly come to this, kind of a conclusion that cow slaughtering ban has been introduced quite recently. It's a modern kind of a public policy dimension that has been introduced only in some states and not in every state. And slaughtering of cows or eating of beef, as it were, is something that is not in favor of public policy in India. While you can slaughter any other kind of animal, which are definitely permitted by law, and you can make meat or have meat, slaughtering of cows and other milch and draught cattle is banned in this country, and this ban came only recently. I think this is not true at all. I think it is just about a government trying to invoke an old provision of law, trying to invoke the original basis of the Constitution, as it were. Now, if you go to the Constituent Assembly debate on Article 48, it's quite interesting. It's interesting because there was a big debate about should there be a specific provision in the Constitution which prohibits the slaughtering of cows. Why should the Constitution determine what you eat, what shall be the meat, and what is the purpose of bringing this provision? Now, you will notice, obviously, a certain section of the community in the Constituent Assembly did oppose to this provision in the Constitution, saying that this is unnecessary. And the Constitution saying so is completely not required. So I think the Constitutional Assembly debated this, and I think at that point of time, the public policy concerns among a majority section of the community was that look, it's one that for a particular kind of a community, cows were considered to be holy or sacred or some kind of divine purpose, and hence that community wanted protection of cows. That community wanted saying that no slaughter of cows shall be permitted and states should take this endeavor. So please know, it is the Constituent Assembly, it is the Constitution that is saying so, which means it is all over India a policy that had to be implemented. However, the central government said, let the states do it. Let the states take this initiative. And they believed that that was the right public policy at that point of time. And hence, to some extent, you may say that while Article 48 was brought into place as an original part of the Constitution, you would say, was it a public policy of the majority at that point of time? The answer is an absolute yes. Did it trample upon the rights of the minority? Uh, Sometimes at their cost, yes. Because remember, friends, public policy cannot be a unanimous opinion. Public policy or public administration is not based on each and individual consent or each and individual acceptance of public policy. It is sometimes necessitated to protect many aspects of public administration and public morality. And to that extent, I think you will notice that this was brought into existence. Interestingly, friends, while we say that this is how public policy is, you will notice that in the case of protection of cows or other milch and draught cattle, in bringing in legislations to actually prohibit cow slaughters, states like Kerala, Arunachal Pradesh, Meghalaya, Nagaland, Sikkim, Tripura, Manipur, and Mizoram have no such law. But the rest of the country has a law that actually makes cow slaughter an offense. So 22 out of 28 states have banned cow slaughters. Yes, and this is something they had to do it or they were willing to do it because this was under the state list of the 7th schedule. So though the constitution says so under the directive principles of the state policy, the states have a choice, to follow the directive principles as the case may be. Now look at the interesting dimension of the state policy, because states can have differential policies than the national government. That is the beauty of public policy. Respecting that in a cooperative federalism process is the beauty of public policy sometimes. But the only thing is it should remain with the dominant will of the state. And the state can then exercise the reservation of creating an exception to Article 48. And this has existed for the past 70 years of the Constitution. Why? Probably because if you look at the states, Kerala, Arunachal Pradesh, Meghalaya, Manipur and Mizoram, here is where probably the food habits of the community does probably allow them to consume beef. And hence for them probably the cow is not a sacred animal. These are states that have been dominated by a certain section of the community, and they have continued to hold that position despite major political parties coming to power over there. So this very interestingly looks at the dimension of not only say a Hindu versus Muslim dimension. To be honest, it looks at probably the dimension of public policy as laid down in the original constitution, as laid down in the law from time to time, and as laid down as an reservation of exception of certain states, right? So I think the cow slaughtering legislations, you will notice, friends, were passed as early as in 1955, 1960s. They're not new legislations at all. What happened in the recent times is, in these legislations, the government that came to power, they wanted to revive these legislations probably. They wanted to bring about greater awareness of this legislation. They wanted to probably effectively implement this legislation. And for which what they did was, in certain states, they enhanced the punishment for cow slaughters. That's all. In certain states, they actually decided to monitor which kind of cattle is being taken to the slaughterhouse or not. And most importantly, you will notice that in many of these states, they started monitoring border movement of these cattle. So they said that, it was probably like, say, I can give the example of Karnataka. It was easy to transport these cattle from Karnataka to Kerala and then take them to the slaughterhouses. So, because in Karnataka it is prohibited, so take them to Kerala and you will be in the right side of the law. So this kind of ban on interstate movement of cattle for slaughter was attempted to be regulated by bringing in some changes and amendments to the existing cow slaughter law. And that revived the debate. But please note, it was not anything new. It was just the same public policy of the Constituent Assembly. It was the same public policy at that point of time in 1950 that continues even now. Probably what we have done is, in the strengthening of the public policy in terms of effective implementation, certain measures were taken from time to time. Now, there are a couple of very interesting cases on this which probably can be of some guiding light to understanding how public policy on cow slaughter was taken into due note and consideration of. The Hanif Qureshi case was a state of Bihar, decided by the Supreme Court in 1958, is a great example of the kind of challenge that was taken to cow slaughter. People felt that just having a special protection for cows and not to other forms of cattle, uh, looking at protection of cows for what purpose? Milch cows and those cows that probably add to the white revolution. Uh, so I think a challenge was taken to the Supreme Court saying that, look, why don't you look at the legitimacy of Article 48? Why don't you look at these cow slaughtering legislations, whether they should be held to be legal or they should be held to be unconstitutional? A lot of people went to the court and said, look, this has shut down our business of slaughtering houses. It has taken away our right to food sometimes, and so on and so forth. I think the challenges were on multiple grounds and multiple fronts. They also did claim that this kind of a provision in the constitution is only one-sided. It actually takes the side of one community altogether. Uh, for example, there is no mention of non-consumption of pork in the constitution. So, does it violate the butcher's right to a career as enshrined in Article 19.1g? Article 19.1g is about the freedom of trade, occupation, and business, and whether this kind of restriction on cow slaughters affects such a freedom. I think the court clearly rejected this argument, and the court said that, look, protection of cows is not, just a matter of economic profitability. It is a matter of a national consciousness. It should be laid down as the public policy of the nation, as it aspires to, a larger section of the community to hold this cow as a sacred, holy animal, and to protect these kinds of cattle for milching, white revolution, milk, and other purposes. It's very important that such a ban on cow slaughter be protected, and it is under the general interest as well. Interestingly, in some of these legislations, you will notice that some of the legislations have a very clear ban on cow slaughter. Very clear. It's called the absolute ban on cow slaughter. So they say that none of the cows, whether they're milching or any other cow, should not be slaughtered. In some states, you will notice they make a distinction between a milching cow and other kinds of cow, and some can be slaughtered and others cannot be slaughtered. So this kind of a distinction of ban is also something that some states have exercised as a discretion. So, is this in general interest to the public of that particular state? The answer should be yes. If it is general interest to the public of that state, then that should be determined as the public policy of that state and then collectively of the nation. Please note, friends, when you try to determine public policy, one of the tests that you should remember is what was laid down in the Keshananda Bharati versus State of Kerala case, where the court said, remember, public policy means that the national interest shall take precedence over the interest of a specific group of people. Simple. That's public policy. National interest shall take precedence over the interest of a specific group of people. And the national interest of inscribing Article 48 was very clear. And that has been stated, reiterated by the Supreme Court of India. So ban on cow slaughter continues to be an integral part of the Constitution's directive principle. Whether it's an absolute ban or with an exception, I think that is the consideration of public policy that we should appreciate and understand. Now, look at it from a perspective otherwise. Now, the ban on cow slaughter means cows in India or cattle in India to some extent, milching ones, have certain rights, right? They will not be killed, and there is a law that protects the same. So, to be honest, if you ask me, the cow slaughtering legislations or the anti-slaughtering legislations, as we would want to call it, are legislations protecting animal rights. So, protecting animal rights, not in, see, none of these rights are going to be absolute in any form or any manner, but protecting animal rights, isn't it part of Article 48A? Isn't it part of the duty of the state to protect the environment and wildlife? Isn't it part of the duty of every person in public interest to respect the rights of animals? So I think animal rights have taken precedent in 48, it's not general animal. Maybe cow is a specific animal for the country. Every country can have one national animal, can have one animal for the protection of constitutional principles. And the Indian cow has been granted that kind of a special status right from the time the Constituent Assembly debated putting this specific article in the Constitution. Please note, today there is a growing debate on the rights of nature. Should nature have rights? Now, which is the form of nature? Maybe forest has been debated for a long period of time. The Uttarakhand High Court very recently held that the river Ganga has a right of its own. It has a legal personality of its own, though the same judgment was stayed by the Supreme Court later on. So, if anyone pollutes Ganga, that is the idea, right, of the Uttarakhand High Court. If nature has its right, if river has its right, if someone pollutes it, uh, then there can be an allegation on pollution on behalf of Ganga. So, I don't have to file a case on behalf of the Pollution Control Board of the state. I can be the person who takes the case of contamination of pollution of Ganga on behalf of Ganga. So I think tokenism is definitely something that was attempted in that case to give nature certain rights. But I think the larger message of public policy, which has always stated in India, is I think in India it has been a very integral cultural practice that nature gets the respect that it should deserve. We kind of revere each of these things in nature, be it forests, be it rivers, and that's why you notice that rivers have been named after god and goddesses. Ganga, Kaveri, Yamuna, Brahmaputra, so on and so forth. So that once there is this kind of reverence to religion, holiness, divinity, then there will be a greater degree of responsibility and duty to protect, the duty to conserve, not to exploit, not to usurp, and not to pollute. So right now, if we just take this kind of small thing. So this is statistics to 2018 about India's national and state cow protection laws. So if you just have a quick look over here, uh, some of these legislations make the offense bailable, some of them make it non-bailable as well. So some of them are very strict in that sense. Okay. So what are the laws on protection of cow and cow progeny? You will notice that one, we have Article 48. Then we have the Prevention of Cruelty to Animals Act, 1960. You cannot kill any animal in a cruel manner. Please note it down. Okay, though it is a cognizable offence, duty of a person in charge of animals to take responsible measures to ensure the safety of animals. So, killing cruelly is also punishable under 1960. So, the way you slaughter is also critical and important. Okay, right. So, empowering police officer, this is fine. Now, let's look at Andaman and Nicobar Islands, friends. Okay, we think some of these islands are tribal, and cow slaughtering or any other thing is the only method of having food, isn't it? 1967, prohibition of cow slaughter rules were brought in the Andaman and Nicobar Islands. You cannot slaughter or cause to slaughter cow, bull, or bullock without certificate from a veterinary officer of the competent authority. The fine is 250 rupees. Okay, so that is the Andaman and Nicobar Island law. We'll go to Punjab, which probably many of you may not be aware of. Punjab brought this legislation in 1955 itself. You cannot slaughter or cause to slaughter, offer to slaughter uh, any cow. There are exceptions in self-defense, of course. You need a certificate. Maybe it's an infected animal with contagious diseases. So it's not an absolute ban, right? There are certain exceptions that can be created as well. You cannot sell or cause to be sold, offer to sell beef in Punjab. Now, Punjab, please note, is dominated by the Sikh community. But, that's a state that continues to hold cow as an important constitutional animal or whatever it is in terms of protecting the identity of this same. Cannot export or cause to export cow for slaughter. That is also something that is regulated under the Punjab law. Goa also cannot offer to slaughter Goa also has the same animal that is protected. Of course, an infected animal can also be taken for slaughter. That's something. Culling of animals is something that is often allowed. You cannot sell beef in Goa, and that is something that again comes with a fine of 200 rupees. Okay. Uh, just to have a kind of a glance of public policy on cow slaughter in different states. Uh, Please note, what we are trying to do is trying to look at the constitutional mandate and then relate it to the state public policies, which probably then also will tell you or display to you what is the public administration required vis-a-vis cow slaughter, right? You will notice that we are also here going to speak about uh, who is a competent authority. You will notice that there are designated competent authorities under these legislation, what they can do, how can they implement this legislation. So in Delhi, which is the 1994 Act, a sub-inspector is also authorized on behalf of the government of Delhi. He can enter, stop, search vehicles, seize animals. So these are the powers that they have. You cannot slaughter, you cannot sell, you cannot possess the flesh as well, right? This is now quite the strictest of legislation that we have already come across. You cannot transport or cause to be transport. You cannot directly or indirectly export. So you will notice that as we come closer to the time in which we are discussing this course, the legislations get stricter. The legislations actually include direct and indirect acts in their vicinity as well. Now, compared to this, friends, you will notice that most of the countries across the world don't treat cow as a holy animal. So the public policy in Australia is to consume beef. That's their public policy. They can cut, kill, slaughter, use. That's their. But in India, the public policy is slightly different. So I think this is where cultural aspects to any constitution affect the direction of public policy in that country. Culture does come into place. Religion also comes into place. Community and other aspects also play a very critical role in determining the constitutional public policy as it were to be said in terms of what should be the public administration over there, right? Um, of course, the meat industry is considered to be one of the highly contaminating industry and a major contributor to climate change today. So many of these Western countries who advocate that India must take some kind of an action towards climate resilience and climate protection must first of all reflect themselves in terms of saying, are we the biggest emitters of carbon in terms of climate? So anyway, just to tell you the background of the public policy and climate change and how it's related to protection of cows. So in one sense, we are at least having the largest cattle population apart from having the largest human population. And I think protection is the measure that we have taken so far. Though from protection of these cows, there is an element of production of methane, as it were alleged by the climate activist. Puducherry also has a legislation which is a former French colony. Uh, Andhra Pradesh also has this. They don't allow certain animals to be used for sacrifice as well. So those are legislations over there. So yeah, this is an exception that is created actually. So yeah. So recently, Assam bought this legislation on cow slaughter. Initially, Assam was not part of this. So Assam has a new law on cow slaughter right now. Yeah, so I think that should be good in terms of understanding this aspect on cow slaughter. So I think here you will notice that this gives you kind of an understanding of how the debate or the analysis of the constitution will have a very important influencing factor on public administration as it were. So from here on, I think we move on to the preamble of the Constitution and fundamental rights. This was the introductory part. So what we have done in this is to link the Constitution to public policy and public administration. We have looked at Constitution and its structure, the purpose of what the Constitution does, how is the Constitution being framed, from where it got its inspiration, what are the different parts of the Constitution is what we have done in this session.